My name is Bob Pure. I have the privilege of being president here at GCC and the honor of welcoming each of you here. Alexa and the Bar Association doing all the good work that you are doing, that you're going to hear more about as the day goes on. The district attorney and the extraordinary leadership that he is providing for our community in 2 counties having to do with the very issues that we're all here to talk about today. So it really is an honor to welcome you all. For about 51 years, GCC has opened its doors to everybody who wanted to have access to higher education, to pursue a better life for themselves, for their families, and in doing so, strengthen our community. You have been helpful in making sure those doors remain open for all of those 51 years. The work that you do every day in your commitment to civil rights, make sure those doors are open. But we realized a few years ago there was more work to be done, and so structurally we removed a barrier. We removed the front steps, 44 steps, for those of you who haven't been here, 44 steps that led up to the front door. And we removed those steps, more than symbolically removing yet another barrier to provide access for those who wanted to work hard for a better life for themselves and their family, and in doing so, strengthening our community. There is still more work to do. We know now that economic status is a better predictor for success in education than race. It's the first time in the history of this country. Poverty is more violent, causes more war than any religion, than any nation has in the history of our world. Poverty is the soil that evil grows out of. Poverty, as Martin Luther King understood, connects today's conversation with the future of our country. The work that we need to do together is about maintaining those doors open, keeping those doors open to quality education, so that on the other side of that door, every student has the opportunity equally than the student that goes to the school down the block. So, let me therefore welcome you to this conversation this day. I won't continue to go on with that, but I know that you all every day do the work that needs to get done on the legal side of issues. You are absolutely advocates for every student of ours that wants to walk through those doors and those who don't even know the doors exist. So with that, I'd like to ask Alexa to come on up and begin your conversation about today's topic on civil rights. Welcome.
Good afternoon. Thank you all for being here. I'm Alexa Flanders. I'm the current president of the Franklin County Bar Association. I want to thank especially GCC for hosting us again and letting us enjoy this beautiful space, and thank those of you who've come out on this gorgeous day and sacrificed some of your time to be here. I want to especially thank our panelists, attorneys Bill Newman and Pamela Nolan Young, and Dr. Amakal Shabazz for generously volunteering their time as well. Thank you to Buzz Eisenberg for being our moderator, and special thanks to the Northwestern District Attorney's Office for supporting us this year as well. I have many more thank yous. It's a little bit like the Oscars, and if I go on too long, I hope somebody in a gown will come and take me away. But a lot of work went into today on a variety of levels, and I want to acknowledge the people who've done that. First, the scholarships that we'll present momentarily, the funds for those scholarships were raised by a couple of different events. There was a tennis tournament last summer that was spearheaded by attorneys Byron Capeless and Dave DeHert, and there will be another one in June, so everybody get your game ready. And then there was our ever-popular trivia night took place last month, and the committee consisted of Jeremy Bucci, Isaac Mass, Katie Schendel, and Dorothy Storrow, and David Singer emceed. All of the above were overseen by our hardworking director, Chris Baronis, so thank you, Chris, for all that you do. Our Law Day committee this year included Jennifer Derringer and Steve Gagney, and we had help from Mary Carey and Martha Murphy-Kane from the DA's office, but special thanks go to Yana McClure, without whom this day would not be possible, who really did so much work. Thank you so much, Yana. This year's theme set out on the cover of your programs is Realizing the Dream, and we're asked to look at the 50 years that have gone by since Dr. Martin Luther King Jr.'s I Have a Dream speech and see in what ways we have and have not fulfilled the promise that he set out. And I'm going to quote briefly from someone who's much more eloquent than I am, that would be President Barack Obama, in a proclamation that he issued yesterday about today's Law Day, in which he said that today we remember when Dr. Martin Luther King Jr. stood in Lincoln's shadow a century after the Emancipation Proclamation and gave voice to a dream sounding the call for an America that truly lives out the meaning of its founding creed. We honor the courageous men and women who fought to bring those ageless ideals of freedom and fairness into the rule of law, from the Civil Rights Act and the Voting Rights Act to Title IX and the Americans with Disabilities Act. But President Obama continued, even now that work is not yet finished. Opportunity remains painfully unequal for too many among us. Justice too often goes undone. Law Day is a chance to reaffirm the critical role our courts have always played in addressing those wrongs and aligning our nation with its first principles. Let us mark this occasion by celebrating that history, upholding the right to due process, and honoring all who have sustained our proud legal tradition. It's particularly apropos that we are having so many anniversaries associated with this Law Day because this year is the 200th anniversary of the Franklin County Bar Association's existence. There are copies on the back table of a supplement that will be published in the Recorder this Friday that kind of goes through some of the history of the Bar Association, the function that it played at its founding, some of its more recent innovations, and some of its luminary past members. I have just a few more thank yous. I want to thank attorneys Lisa Kent and Jack Curtis for articles that they wrote. Research for this supplement was done by GCC student William Comfort. Chris Baronis has done lots of work on it, and particularly Dorothy Storrow, who spent countless hours editing and writing and was the driving force behind that. So now I'm going to turn to the scholarships. This is something that we've only done for the past few years. This year we had the most applicants ever, and they were extremely well qualified. And the scholarship committee, I'm sure, had a difficult time deciding who the scholarships would go to. But two applicants really stood out for their academic excellence, their well-written essays, and their thoughtful answers to the question about whether or not we've realized Dr. King's dream. The first of those recipients could not be with us today because she had a prior commitment, but I'll tell you about her briefly. Her name is Alyssa Adams. She is a Turners Falls resident who is a senior at Turners Falls High School. And despite a very difficult personal life, she has managed to excel. She's a wonderful student. She's involved in a host of volunteer activities and other extracurricular activities, despite having gone to 10 schools over the course of her schooling. Now she is an independent, and she will be putting herself through Clark University on her own. In her essay, she talked about how she was a co-founder of her school's Gay-Straight Alliance and how we need to do more for full equality, whether citizens are gay or straight. She participated in the Upward Bound program at Northfield Mount Hermon, which is designed to provide low-income students with the skills and motivation they need to succeed in high school and college. And she had a glowing letter of reference from that director. And she's on the honor roll in Honor Society, and so a very well-qualified applicant. Our other recipient is here. It's Forrest McBarry, who is a Greenfield resident and a senior at Four Rivers Charter School, where last semester he had a 4.0 grade point average. He is a varsity basketball student and an active volunteer at the YMCA. He is described by teachers as a leader, an analytical thinker, and a bright and hardworking student. He's doing a senior project studying alternative energy and writing a plan to reduce Greenfield's dependence on non-renewable energy sources, and he will be attending Clark University this fall. Forrest wrote a very well-researched and extremely well-written and thoughtful essay, complete with footnotes, and maybe you don't know, but lawyers love footnotes, so I really appreciated those, discussing threats to the vision of racial harmony that Dr. King imagined. And he cited statistics on the growing number of hate groups in the country and gave specific examples of recent high-profile racially motivated crimes and other incidents of racism that comes up in social media and other venues. And he concluded, foreshadowing President Obama's proclamation yesterday, that while our society is immeasurably changed since the days of Dr. King, activism in the name of equality is still needed in order to bring about King's future. So I am very delighted to ask Forrest to come up and receive his scholarship. So now I'm going to invite our panelists to come up. Please, you can just come up as I'm talking and take your places. And you're going to be officially introduced in a moment by District Attorney David Sullivan. So he's going to be up next, and I just want to introduce him briefly, although there's lots to say about him. In his many years of practice, he has seen the criminal justice system from every perspective. He tried cases for years in both criminal and civil contexts, in Superior Court, District Court, Juvenile Court, and Military Court. In 2002, he was elected as the Register of Probate in Hampshire County, and in that capacity, he worked to expand access to courts through user-friendly website and online forums. He established mediation programs to help parties resolve disputes out of court, and in general worked to expand the public's access to the probate and family court. In 2010, he was elected as the Northwestern District Attorney, and he took office in January 2011. And the mission of the office is to advocate for making communities safer and stronger while protecting civil rights and promoting social justice. And DA Sullivan not only talks the talk, he walks the walk. His office sponsors a variety of community outreach programs, including raising awareness about sexual assault and child abuse, consumer protection, other campaigns. There's a current push to create a veterans justice program that will divert veterans out of the criminal justice system and into treatment. And the DA's office is a generous sponsor of worthwhile causes like the one that we think this one is, and we're very grateful to the support that we've gotten from the office. And Dave is a very visible presence at this type of function and other social justice-related events. So on behalf of the Bar Association, again, thank you for your support, and I'm delighted to introduce David Sullivan.
Thank you, Alexa. I want to thank the Franklin County Bar Association that's really been a leader for law days for many years and really bringing the justice system into the community to let people know what lawyers and judges and really the citizens do in our justice system and how important citizen participation is. So on behalf of everyone, Alexa, I want to thank you and Chris Baronis, the executive director, for really spearheading Law Day for these many years. This year's theme for Law Day is realizing the dream, equality for all. And we all know in this room that our founding fathers and mothers, sisters and brothers, founded a nation with the aspiration of equality for all. But that hasn't truly been achieved even today. And we have two significant events that we're commemorating at Law Day. And the first was when Abraham Lincoln gave his proclamation, his Emancipation Proclamation, freeing African Americans from slavery. But that proclamation really didn't achieve equality for people of color in the United States. And we know that because 100 years later, when Martin Luther King spoke in the shadows of Abraham Lincoln's shadow and his monument on the mall in Washington, D.C., there was still Jim Crow. There was still discrimination against many people in our country. There was poverty that President Pura talked about that has dragged our people down in our society to where we can't really achieve equality while people are still embroiled in poverty. So we know that as we move forward, and we know that freedom for many people, women that needed to achieve some amount of equality at the voting booth through suffragette movement to get the right to vote, that was achieved through a lot of blood, sweat, and tears. And so did the movement for civil rights in the 1950s, the 60s, and the 70s, and it continues. So we're here today to really talk about the dream, what we have to do to get there, what the reality is of civil liberties in our society today. And our panel today is a very distinguished panel. It talks about, and it will talk about, contemporary issues in civil rights. And so I want to introduce to my left, our first panelist is going to be Buzz Eisenberg. For those that are from Greenfield Community College community, Buzz is a professor of criminal justice, a very distinguished attorney in the Franklin County Bar Association, and has been one of the significant advocates for justice for those detainees held in Guantanamo Bay, Cuba. So thank you for your work there, Buzz. Our next panelist is Pamela Nolan Young. I've known Pam for many years. She's been a real significant force in fighting discrimination, in creating diversity in the workplace. And in particular, she is an advisor to the president of Smith College, and she is the director of the director of institutional diversity and equity at Smith College to try to achieve equity within that institution, both for students, faculty, and administration, and for those citizens that need to access Smith College. Our next panelist is Bill Newman, known to many of you from his hosting of WHMP radio show, and he has always been a great spokesman for civil liberties. His current role is not only as an attorney and as a radio host, but also as the director of the Western Mass office of the American Civil Liberties Union. Our last panelist is Amilcar Shabazz. Dr. Shabazz is a professor at the W.E.B. Du Bois Department of Afro-American Studies at the University of Massachusetts. He also has been an individual that has fought his entire life for diversity, for equity, and for justice. He holds a position that's very significant at the University of Mass. He works with the chancellor as a faculty advisor on diversity and excellence, and that's to make sure that UMass lives up to its aspirations of equality for all. So without further ado, I just want to welcome our panel and thank you all for being here. And I think, Buzz, are you going to be kind of the moderator? Okay, great. Thank you all.
I just wanted to thank David, not only for the introductions, but we were fortunate to have a district attorney who is not only interested in public safety, but is interested in social justice. It's not all counties are as lucky as these two counties are, and I want to thank him. So we are here to explore contemporary issues, inequality, and I'd like to start with Pamela Nolan Young to my left, and I'd like to ask her about a case that was argued in early March before the Supreme Court, apropos to Bob's comments about our desire, our struggle to maintain doors that open to all people, regardless of income, regardless of differences here at GCC. Could you talk to us about the Fisher case?
I'd be happy to. Let me give you just a little summary about the Fisher case. It's the University of Texas versus Fisher. Abigail Fisher applied to the University of Texas at Austin for admission. The University of Texas has sort of an unusual admission policy in that by state law, they take the top 10% from each of the high schools in Texas, automatically admitted into their class. And that fills, as you might imagine, a large percentage of the incoming class, between like 80 or 90% in any given year. And the remaining slots are then, very competitive for the other applicants. Abigail applied and was denied admission, and then challenged that denial based on the fact that other individuals were accepted at the University of Texas, and she alleged in her argument that their admission was based in part on racial preference. So the University of Texas has a two-part system where they look at a number of academic factors as part of a scoring And then they look at another set of factors that are based on a range of things, including socioeconomic status, activities that you might have been engaged in high school, and together those two scores then become the deciding factor for the selective part of this process for admission. And based on her combined score, she was denied admission. So the case has now reached the Supreme Court, and they will be delivering a decision likely in June at the end of their term about the use of race as one of many factors in the admission decision. And this case is important for a number of reasons, and I think you might be asking, why is it important here at GCC, which has, as we know, open admission. You apply, you walk in the door, you pay your money, and you're able to have access to a fine quality education. And let me just add as a personal note that community colleges have a special place in my heart because I was the HR director for 5 years at North Shore Community College, so I know the community college system in Massachusetts fairly well. Abigail Fisher's case is important for GCC and for all of higher ed because it really looks at how does the college decide what the composition of their class should be, whether race should be a factor, whether race can be one of many factors. And you might have, there might be a difference of opinion on whether race should be used at all, but I think more important than that, what we have learned about diverse higher educational systems is that they allow for students to have a more well-rounded education. They provide avenues for critical thought. When you have a homogeneous group of people approaching a problem, they generally think about that problem in the same way. And so by having diversity, whether it's based on race or socioeconomic status, or any other number of factors, helps colleges and universities to have a student body that is going to be more creative, more nimble, and one that we know it reflects not only the changing demographics in the United States, but also our ability to be more dynamic role player on the global stage where we are involved in a world that is very, very diverse. So I'll start there as an opening.
Thank you. Bill Newman. I learned listening to Bill's radio show that I should say Bill Newman, director of the Western Massachusetts office of the American Civil Liberties Union, every time I talk to him. Bill Newman.
I don't know what Buzz listens to, but then I've never known what Buzz listens to be honest.
There was another case argued this session before the United States Supreme Court involving voting rights, and particularly in Shelby, Alabama. And the question before the High Court was whether or not the remedial efforts, that is to remedy past injustice, which resulted in the Department of Justice monitoring the performance of the election authorities in Alabama, was still necessary. Could you talk to us about that case?
Yeah, thanks, Buzz. Excuse me. This case involving Shelby County, Alabama, essentially is a test case brought by right-wing legal groups to try to gut the Voting Rights Act of 1965. That's what it is. And they may succeed. That's also, I'm afraid, a realistic view of what this court may do. It's going to come down to what Justice Kennedy decides, as it often does in this Supreme Court. At issue is the requirement in Section 5 of the Voting Rights Act for the Department of Justice to give pre-approval to changes in election procedures in various states, mostly southern states, but also including California, or parts of California, Florida, New York, and South Dakota as well, Michigan and New Hampshire. So this was a law that required congressional reauthorization, and when it came up for reauthorization about 4 years ago, the United States Congress overwhelmingly found, I think unanimously found, that there was a need for this law, that the roots and branches of segregation and discrimination and voting suppression in various states required that the law be renewed, and then Congress voted overwhelmingly to renew the Voting Rights Act of 1965. Prior to that, there had been a plan afoot among various conservative groups, who I think essentially are interested in voter suppression, to challenge the law if it was renewed. Shelby County is the case. Shelby County takes the position, racism is not an issue. We're pretty clean in terms of racial discrimination, notwithstanding that there are all sorts of indices and indicia of it in Shelby County, including specifically around voting. How important this case is and how dramatically the Supreme Court will affect the concept of equal protection in the United States and in the laws of equal protection cannot, in my judgment, be overstated. I want to do a little bit of a history lesson. That okay? Because if it's not, just please leave or something. Look, we say as Americans that we enshrine, we venerate the concept of democracy, which is to say, in part, that we believe in the importance of the ballot. The founding fathers, and the mothers didn't count, let's be clear about that, did not really believe, sorry, Mr. District Attorney, they didn't believe in democracy. What they believed in was an unrepresentative representative democracy, in which the representatives were chosen, that is, voted on, by men who were white, who owned property, who were not Catholic or Jewish or Quaker or Native Americans, who were 21 years or older at a time when approximately 20% of the country were African American and mostly slaves, and half the population was 16 or younger. Somewhere between 1% and 4% of the country voted for George Washington for president. Now, the story does get better. Since 1789, or for the better part of a couple centuries, America increasingly allowed participation in the democratic process. That is, there was, in fact, a sea change over the course of time to allow many more people and groups to participate. So, in the post-Civil War amendments, the 13th Amendment, which abolished slavery, the 14th Amendment, which guaranteed equal protection, said no state shall deny any resident therein equal protection of the laws, and the 15th Amendment, which guaranteed the right to vote. Those were enormously significant, and they have within them as their final sentence that Congress has the right, through appropriate legislation, to enforce these guarantees. The Voting Rights Act is specifically envisioned within the 13th, 14th, and 15th Amendments. That said, let's go through a little bit more of how the right to vote has in fact become, well, we would say venerated or enshrined. It's certainly become a realistic part of America and what we think of as the fabric of our democracy. So, 1913, the 17th Amendment provided for the direct election of senators, who, of course, as you will recall, were elected at the founding of the country by the legislatures of the individual states. The 19th Amendment in 1920 gave women the right to vote. In 1961, the 23rd Amendment gave the District of Columbia residents the right to vote, but at least for a president, but not, of course, for any senator or congressional representative. In 1964, the 24th Amendment was passed. It abolished, this is 1964, okay, this is not ancient history, abolished poll tax, the poll tax in federal election following a Supreme Court, or actually in anticipation of a Supreme Court case that eventually held that poll taxes violated equal protection. In 1971, the 26th Amendment was passed. That guarantees all citizens of the United States 18 and older the right to vote. Here's the math. 27 amendments, but the first 10 really were adopted as part of the Constitution, and the 11th, ratified in 1795, had to do with the federalism concept and a tweak in that concept. So, we have had 27 amendments in 220 plus years. 2 of those amendments dealt with prohibition. 1 instituted it, one revoked it, so let's call that a wash. They don't really count for this purpose of this math problem. And what we end up with is 14 substantive amendments, 12 of which directly focus on the right to vote. Now, these amendments to the Constitution came, as District Attorney David Sullivan points out, with a lot of blood and sweat and tears. And they are victories that need to be protected. They are victories that, in my judgment, are under attack. And you don't have to go back any further than the last presidential election and the voting therein, in which the following were prominent, although not determinative, last election. Voter suppression. Condemned, certainly not by the courts. Look what has happened in voter identification laws that were passed. Now, in Pennsylvania, for example, they were put off till the next presidential election, but they're on the books. They're going to be enforced. Proof of citizenship laws, all the things that can prevent a person from voting. Limitations on early voting. Very, very important if you really actually want people to participate, because guess what? Some people actually have to work. Some people can't get to the polls either early in the morning or late at night. Some people don't have 4 or 5 hours that they can miss work, because voting's important, but so is earning your paycheck so you can put food on the table for your kids and you don't get fired. But that actually doesn't apply to all those retired voters, most of whom tend to vote for a certain party. Purging of voter lists with people not able to get back on, widely reported in many states. Felony disenfranchisement, which is prevalent throughout the country. Why, if you serve your sentence and you get out and you raise a family and you work and you have a job and you participate in your community and you do all those things, why can't you vote? I don't get it. I really still don't get it. You've done your time. You've paid the price. You want to be a contributing member of the community, and what do we say in the United States? Yeah, but don't vote, because that would make you an equal person. Many states. Registration requirements becoming particularly onerous. Voters being challenged at the poll themselves, which ends up in a lot of frustration and sometimes people just moving. A whole panoply of dirty tricks. Misinformation, robocalls, your voting place has been changed. And then you show up and then you don't have another 2 hours and then there's no one there to tell you where to go, so you don't vote. There is, in fact, a strong movement afoot in the United States to make sure that people do not vote, that racism becomes more and more prevalent, and that racism infects the right to vote, or what we perceive of as the right to vote. This challenge to Section 5 of the Voting Rights Act is a microcosm, perhaps a focused one, of all of these efforts to make us less democratic and less free. And I am very worried about how this case is going to come out.
Dr. Shabazz.
Yes.
I didn't mean to be such a downer, by the way.
Good.
I'm glad I went before.
I'm gasping for air.
Good afternoon.
I just wanted to pose the question in the context of what we just heard. I mentioned the word remedial before. That is that affirmative action, the Voting Rights Act, the Civil Rights Act, they were remedial in nature. They recognized past injustice and imbalance, and their purpose was to rebalance the scales. At the Supreme Court, an Associate Justice of the Supreme Court actually said we're living in a post-racial United States. Part of the argument in Fisher involved the increased numbers of minorities that attend college. It involved the fact that while that we've cut in half the number of, I think now 27.5% of us living in poverty are minorities, where it used to be 54% 50 years ago, and celebrated that that fact that the President of the United States is of a minority, and that we are tipping. We're right at the tipping point of the scales in terms of the majority is about to be minorities, and of non-whites in this country. So in the context of both the Fisher affirmative action case and the Shelby voting rights case, are we living in a post-racial United States?
Yes. Thank you very much. Thank you to Greenfield Community College for being the host of this event. Greenfield Community College, no stranger to me. My son of the same name attended here, took very fine classes, and given him his start where he's now out at UMass Amherst. I, first of all, recognize that race and the problem of racism in the United States of America has changed. We are not frozen in time. Race relations, racial problems, racial inequities are not the same as they were in the year that I was born, in 1960. They're not the same as in 1860. There has been change. The real question, however, in raising the issue of post-racial and whether we're at a tipping point where to think in terms of, and I want to particularly, because of my research area, to think of African Americans, which you can say is a race, part of a race, or you could also think of as a particular ethnic group within the United States of America. Whichever way you want to look at it, the issue is being conscious and having conscious thought, whether in law, such as in Texas with the 10% plan with the high schools, that was a response to the decision in Hopwood v. Texas. Whether you want to think about in Alabama or in Mississippi or in the South with the voting rights, which is in law, that certain things have to be reviewed in Section 5, whether that very cognizance, being cognizant in our policies, in our ways of doing things, in and of itself perpetuates the problem of racism in society. This is the contention. Let me give you a little excerpt from my book, Advancing Democracy. It begins with an epigraph. Our client's victory in the Fifth Circuit is now final. I think the main thing we are learning is that racial discrimination perpetuates racial discrimination. And if we are ever to get beyond that regrettable chapter in our nation's history, it is time to stop doing it for all purposes. Theodore B. Olson, attorney for Cheryl Hopwood, who sued the University of Texas on the grounds that it had practiced unconstitutional reverse discrimination, reacting to the Supreme Court's decision, quoted in the Houston Chronicle, July 1, 1996. Now go into my text. When the incisive wit of Richard Pryor's bicentennial nigger warms my heart, I recall my hopes and dreams in 1976 as a young American who happened to be of color. I had no limits. My vision was to become the first African American to be elected to the U.S. Senate from Texas, perhaps one day to become president of the United States. Of course, the reality and prevalence of racism and white supremacy did not escape me. Like Nat Turner and Dr. Martin Luther King Jr., two of my heroes, I felt I was destined to play a profound role in lifting humanity above outmoded attitudes and practices to higher ground and a better day. I worked hard all through my school years preparing, being a class representative, winning oratorical and writing contests, including Law Day in my hometown of Beaumont, Texas. I read voraciously, especially works considered masterpieces. Then in 1976, the bicentennial of the United States, came my senior year, and time to pick a university where I would further educate myself and advance toward my ambitions. From my peers, teachers, and persons who seemed to be in the know, there was only one choice: the University of Texas at Austin. I do not recall ever doubting whether I would be admitted to UT. My first SAT score was not promising. I retook it on a day when I was struggling with contact lenses, starting to wear them for the first time, and also with a higher degree of test anxiety relative to my first try. The result was a lower score than my first test. Still, I did not worry. I had attended a predominantly white Catholic high school and had taken a college preparatory track of classes. My grades, except for physical education, math, and typing, had all been in the A+ to B+ range. My service activities had been extraordinary. Frankly, I did not have a well-developed sense of the competitive nature of college admissions, and I had never once heard anything about affirmative action that might help me get into UT because I was Black and therefore disadvantaged. In fact, race-based affirmative action did not exist and certainly did not concern me. When my white high school chums, whom I knew I was smarter than, received their acceptance letters, I fully expected to receive mine as a matter of course, and so it ultimately arrived. In the summer of 1977, I attended a week-long group orientation session that instructed me about the important logistical and historical information about UT, or the 40 acres, which refers to the original size of the Austin campus. I learned my first gang sign, the Hook'em Horns hand signal. I learned about the UT Tower as a key campus landmark and how no one could visit the observation deck any longer after some nut went up there with high-powered rifles and shot people to death. I even learned my first Aggie jokes as I was introduced to the intense rivalry UT has with the state's older land-grant institution, Texas Agricultural and Mechanical University. I remember being told that UT had the largest endowment fund for an institution of higher education, second only to Harvard. But never once was I told that people whom the state designated as Negro or Black like me had only recently been allowed to attend UT. I would have to hunt and commit years of my life pursuing and engaging the hard facts of Black admission to UT and other institutions of higher education that the state of Texas had declared for whites only. I wonder how my undergraduate experience might have been different if I had been able to read what is presented in this book. I wonder how the undergraduate experience of all university students might have been transformed if the role and relationship of race to higher education and democracy in the US and Texas history had been a mainstream part of our education. One other part to share with you. So my book works against the grain of some other studies that had come out a little bit previously, including the work by Mark Tushnet, entitled The NAACP's Legal Strategy Against Segregated Education, 1925 to 1950, as well as his book, Making Civil Rights Law, Thurgood Marshall and the Supreme Court, 1936 to 1961. And I hold that those works greatly expand our appreciation of the complexities involved, legal and otherwise, in the struggle for citizenship rights. He shows how the fight against racial discrimination in higher education established the National Association for the Advancement of Colored People, NAACP, as a leading force in mid-20th century challenge to white supremacy, as well as the premier architect of the field of public interest litigation known as civil rights. And I say that even sitting next to the representative of the ACLU. I think NAACP is the premier architect, notwithstanding any other groups.
It's good with me.
And I'm here, I want to say, by the way, with the vice president of our newly rechartered branch in Amherst of the NAACP, Edward Cage.
Hey, Edward.
So in the book, Advancing Democracy, as I go through the development in Texas of a dual system of higher education and the challenge to that system, I found myself, and this book comes out, I'm involved in the research, and I'm in grad school doing it as a dissertation, and then after, just as Hopwood makes its way to the Supreme Court. I'm in my graduate program in history. And let me tell you, I respect something very much that happened there that day when the Hopwood decision came out. The chancellor president of the University of Houston system was a man named Bill Hobby, had been a former governor of Texas, wealthy. He was chancellor there for the salary of $1 a year, just an honorary thing. He was doing it. It really is public service, not for obviously the salary of $1. And he called all his leadership team together. I actually had completed my PhD program. I was on a postdoc in the administration, central administration. He called his leadership team together and he says, okay, this Hopwood decision has come out. I don't know what you know about it, I don't know what you think about it, but I'm telling you, don't do a damn thing different than you've been doing in terms of working on issues of recruiting and retaining African Americans and other groups, underrepresented groups. He says, we're going to hold the line and keep doing everything we've been doing and work harder at it. First of all, he didn't agree with the decision. Second of all, he says we need to have a ruling we need to have an opinion from the Attorney General, who at that time was Alberto Gonzalez, to really define how far does this return of the Hopwood decision back to the Fifth Court, what do you call it, en banc? You know, what are the real implications of it in terms of, for us as a public institution of higher ed, with diversity issues and challenges we've been trying to address, what does this really say to us, this Hopwood decision? I need some clarity because it was a law school case. Does this affect all undergraduate admissions? Are you telling me we've got to return to donors, scholarship funds that were given to help pay for the education of deserving children of color, deserving that's racially targeted because it's racially, we've got to return it? We're not doing that. And Hobby held the line on it. And what I'm getting at in my opening comment to this is that, yes, we may be in a down note with respect to the Shelby case, with respect to Fisher, with what may happen there and these things, but I firmly believe that, and here's where I affirm, since this is a day to celebrate and affirm the important role of our courts and our legal institutions in this country, here's what I affirm. I affirm that we simply have to go back and redouble the struggle, file the suits again, catch those instances, every kind of instance that was just laid out around voting, and push it. Push it in our courts, push it to the forefront, and the same thing in higher education. Okay, that's what they did with the 10-point plan, because UT's numbers were dropping. when they attempted to comply with Hopwood across the board and just stop every factor of thinking about race in their admissions policies. It fell apart at UT. And then the legislature responded by doing the 10% plan from every high school, public high school in the state. If you were in the top 10 of the class, you had an automatic in. Okay? So we'll have to just go right back and begin to understand in the United States, as much as we like this attitude of we've won and it's all over and we never have to go back, racism and other forms of inequities and inequalities, sexism, these things are not things that our culture and our way of life, especially as long as structural economic problems undergird and residential segregation continue to undergird our experience in this country. They are not going away because of one decision in 1954 or one act in 1964 or 1965. That is just not going to, those things are not the end of the road. And that's what we had to kind of learn with the civil rights movement. That's what the NAACP that thought that it was basically out of business by the 70s and, I guess we have nothing else to do. And now we're coming back. We're rechartering our NAACPs. We're rechartering our movements for immigrant rights. We have to come back strong and build a real mass movement to once again demand of our courts, demand of our legal institutions, demand of our legislatures to redouble the efforts to find the right ways, not to perpetuate racial discrimination, but to solve the inequities and the inequalities that still vex us in our society until we do have that more perfect union. Thank you.
Thank you. I just want to throw out a question. I think in response to what you were just saying, and I guess I'd like to address this to Attorney Nolan Young, who's worked so hard on these issues. When I was in law school in the 70s, there was a case called Bakke versus UC Davis. And Alan Bakke was a law school applicant who, according to the facts of the case, was equally qualified to be admitted to UC Davis law as other people who were chosen over him because of a racial preference in order to do exactly what Dr. Shabazz was just saying we have to redouble our effort and try to do. Like Abigail Fisher, those people should enjoy some civil rights as well, is the argument, and that how unfair is it that they do not enjoy the fruits of their labor and their qualifications because of their race, which is white.
Well, I would disagree with you on, I think that there are lots of legacies, lots of special categories that are afforded, or lots of students are afforded entrance into highly selective colleges and universities for lots of different reasons. So we make lots of exceptions. Athletics would be one example. Musicians often will have special admission rates. Legacies, so if at Smith, you might have a better chance of getting in if your mother or your sister or your grandmother attended Smith. So there are lots of different things that that the admission counselors look at when they're making their decisions. Some of them are based on race, some of them are not based on race, but race is never the sole factor. No one gets into Smith just because they're black. No one gets into Harvard just because they're black or Latino or Asian. They get in because they're qualified, and we are looking at a holistic view of the student. And I think actually community colleges are probably the one place in the spectrum of higher education institutions where it's truly open access. But in any other institution, higher ed institution in the United States, whether it's Westville State or MIT or Springfield College, there are generally more applicants than there are slots. So all institutions are making some decision about the composition of their class. And race is never the sole factor, and it's not the sole factor either in admission or the sole factor in why you were denied admission, because admission counselors are looking at the whole student.
Bill, my understanding, what the Chief Justice argued or questioned during oral arguments in the Shelby case is he pointed out that Mississippi, for example, which also was being monitored by the Department of Justice, that participation by minorities had risen to, I think, almost 50% from an abysmal 10% at the time that the monitoring system was created. Things have gotten better. Participation has gotten better. I heard you tell us all those dreadful facts, but about how they haven't. But he threw out facts that indicated that they had. Why monitoring by the Department of Justice so many years after that act?
This Supreme Court has deferred massively to what prior courts would have held is and constitutes clear and unconstitutional gerrymandering. There were 6 seats in Texas that were made and turned into Republican seats on purpose, simply by redrawing district lines. In the last election, where the House of Representatives ended up being comprised of a significant majority of Republicans, the Republicans lost the popular vote for Congress. Republicans won 48% of the vote for congressional seats, and yet hold a significant operating majority in the House of Representatives. This court will defer, and seems to be bent on deferring, to executive and legislative determinations that, as a practical matter, disenfranchise people, that as a practical matter make us less democratic, that as a practical matter are offensive to the ideals of a democracy. I think that what Professor Chabas says is correct. There has been significant movement towards a more egalitarian, towards a more equal and less racist society. That said, the notion that racism has been eradicated is simply wrong. The notion that individuals in power won't be able to manipulate the system to keep that power is wrong. Look, there's one piece that I left out in that list of apocryphal measures that go towards disenfranchisement, and that is voluntary disenfranchisement. In the last election, almost half the people who were eligible to vote didn't vote. Now, it's a large topic. Why don't people vote? And somewhat more voted in the last election and the previous election than in prior presidential elections, but it's still something that we say people died for in wars across the world. The right to vote, and we don't exercise it. Why is that? What is that apathy about? It doesn't take much to manipulate the levers of powers. Let me try that again. The levers of power, so that individuals can be effectively kept out of those positions of power. And so when the Supreme Court's Chief Justice says, yes, but look at all the progress, why should we worry about it? He's not worried about it, because it's not going to affect him, and it's not going to affect his race, and it's not going to affect his class, and it's not going to affect most of the people he knows. It seems also logical to him. I'd like him to go down to Shelby County, Alabama, have a lot of African-American friends, come back, live there a year, and then tell me that's true, because I don't believe it would happen.
Which sort of segues into my question for Dr. Shabazz, which is, you and I were talking earlier about Lawrence versus Texas. For people who don't know, that was the case, I think it was 2003, where the United States Supreme Court reversed itself from 17 years earlier. The question there was whether or not the Texas legislature, a state legislature, in regulating morality within the state, had the, whether it was constitutional to criminalize homosexuality between consenting adults in the privacy of their own home. And the United States Supreme Court reversed itself. I think that Dr. Shabazz sat on a panel to talk about that civil rights issue for that population. And it said, in fact, it's no longer constitutional to criminalize homosexuality. And the reasoning was this, that law sometimes has to catch up with culture. So with respect to what you were speaking to earlier, why should it be a juridical problem? Why should it be a problem for government? Isn't it a problem for us, culturally, to have an equal playing field in the way that we live our lives?
Yes, the Lawrence v. Texas decision in 2003 was rightly heralded at that time as a major blow for civil rights. The background to it involved legal punishments for same-sex sexual activity that included heavy fines and even included life prison sentences if you were caught engaged in same-sex sexual activity. In some states, you could go to prison. You could be sentenced to prison for life. The Texas itself, as late as 1970, Connecticut denied driver's licenses to men who admitted being a homosexual. They would deny you a driver's license as late as the 1970s. So, you know, this was clearly a discriminatory, a unlevel playing field, a very heterosexist kind of reality for the gay, lesbian, bisexual, transgender communities, queer community was clearly, up until Lawrence v. Texas in 2003, they had not fared very well in the U.S. In state legislatures as well as in the courts. And that in many ways has been the, sort of gave a certain momentum, like Brown did to the civil rights movement, gave a certain momentum to the movement that is now pushed even further toward having the right for same-sex couples to marry. And we know we are currently right now still in a situation in terms of state legislatures versus at the national level with the courts in terms of exactly you know, where things are around same-sex marriage. We don't have a uniform sort of national policy that favors and allows that right, but there's momentum toward that. And I think it points out for us an important area in thinking about for Law Day, and is to now study that movement that had brought about those changes in the way we've studied the civil rights movement around race issues, to study that civil rights movement around the LGBTQ community. And of course, Barack Obama coming in, overturning Don't Ask, Don't Tell policy in the military, similar to Harry Truman after Second World War, issuing an executive order that ended the segregated military units, or started the process of ending the segregated military. That was a step. That was a major step. And so we begin to see these things involve the creation of this more level playing field is something that really does involve a cultural shift that involves a real change, but the systemic level, I don't think is really facilitated by the kinds of decisions we have in Hopwood, the kind of decision that we may get out of Fisher. Certainly with respect to Shelby County. I mean, the legislature has, the U.S. legislature did a study, and they looked at ways that they could tweak some of the aspects of Section 5 of the Voting Rights Act. People aren't immune to changing policies, but the basic idea of maintaining federal review of changes in these states where the voting rights were just trampled is a basic aspect. It's a review process to see whether changes are going to adversely impact and add to the litany or add to the that kind of list of problems, or whether it helps to move us away from that kind of voter suppression activity that Bill has talked about. So I think that's why I say the need now is for critical, ongoing attention. We're having the issue at UMass right now. We've been in a strategic planning process, kind of a 2-year or so strategic planning process. And the questions of how do we level the playing field? How do we build, we don't so much use that metaphor of playing fields, but how do we build an inclusive excellence, a campus that maintains the kind of commitment to high standards and academic excellence at the same time as we continue to create the sort of diverse learning community. People feel welcome, people respect each other, people are learning from each other, people are enabling each other to help prepare each other for the real world and the work world. All of the kinds of benefits that came up in the Michigan cases in Bruder and Grutter, that had Condoleezza Rice and Colin Powell coming out to testify, and Fortune 500 companies, the military, saying we're not at that point, that led Sandra Day O'Connor in that decision, those decisions say that we need about 25 years. She gave it she's put a time limit issue on it, but 2013 is not 25. By Sandra Day O'Connor's calculation that carried the day in the Michigan case, we ought to have at least another decade out before you would begin to emphasize mandate race neutral policies as Fisher is looking to do. So that's a little bit what I'll say to that.
Bill, you wanted to follow?
Yeah, I'd like to make 2 comments about that. One is, I think it's worth recognizing how peculiar the court's position has been in the Shelby County case. This is a court that prides itself on being a conservative court. That is, it defers to congressional action. It presumes with a significant level of deference that congressional acts are constitutional. It will not reject a congressional finding of fact, such as, for example, there is, in fact, ongoing racial anomalies in these states and in these counties that are part of the jurisdiction of the Department of Justice under Section 5 of the Voting Rights Act. All of those things, under the theory and the judicial philosophy of this court, says the court should never have taken this case, much less rule in favor of Shelby County, Alabama. What's going on here? What's going on? It's so peculiar. And look at this part, because I think that Pamela Nolan Young's point is very well taken, and I would like to just move that discussion forward a little bit, if I might. This is a court in the Shelby County case that says we are interested, and in the school affirmative action admissions cases, saying we are very interested in this equality of admissions. That is a paramount concern for white people. Now, if the grandparents gave the football field and have it named after them, the odds are Grandpa was white. If there is an endowed chair in the history department with Dad or Mom's name on it, the odds are overwhelming that Mom and Dad are white, because the economics of the country and the history of economic opportunity in the United States says that when you give those sort of preferences to legacies, you're helping out white people. Is the Supreme Court really worried about that? Are they very exercised? Are they saying, hey, we've got to put an end to legacies? Top footnote on the case? No, I'm not concerned about that. That's fine with them. That's not a problem. The economic reality of the country is that there are built-in preferences for white people. The court's not concerned. That's just fine. The theoretical problem of a preference for a person of color versus a white person is, in my judgment, considerably overblown. I'm not saying it has not happened in an admissions decision at some point. But you know what? That black kid who came from a ghetto, who had to somehow get out of an environment that was antithetical to the notions of learning, who made it through high school, who got through college, who worked 3 jobs, who got the same SAT or LSAT score as the white kid who had every privilege in the world, you know what? I'd like to admit the black kid, because that's the human being I want in my school. And all of a sudden the Supreme Court is saying, no, 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 1 point lower on the LSAT. Don't want to have that kind of preference. That would be unequal. Life's unequal. And I think those who overcome it deserve some preference in saying, yeah, we're going to reward that effort. We're going to reward that kind of stamina. We're going to reward those who have that kind of merit. And we're going to reward those who say, you know what, I can't work that hard to make that dream come true for me and my family. And I didn't get it because Dad had a bunch of bucks.
Are there any questions? We have time for a few.
The rest of the state on the issues that you before mentioned. What were any of the attitudes at the other universities throughout the state of Texas?
More typical was the reaction of Rice University, just down the street from University of Houston, which was like, oh, we're changing everything. It's all got to go. All that race stuff has to go. When Rice also is a private institution, it's, you know, it wasn't even really, if U of H could say, University of Houston could say, let's wait a while to figure out how this thing shakes out before we start ending programs. Rice had even more of a leg, a kind of a legal leg to stand on as a private institution, but immediately they caved in that way. And you're right, UT, even though it was the focus in the limelight with the Hopwood case, the trustees started openly talking about, you know, we still want to maintain a diverse campus. We're going to maintain a diverse campus. Many of the trustees came out that way. The folks in the state legislature, which is situated right there in Austin, started instantly looking at ways, the Higher Education Committee of the Texas legislature to find, that came up with the 10% plan. So there was really, I think the pattern of sort of caving in and the pattern of sort of, you know, almost embracing it really followed the more red areas of the state, far out West Texas, certain parts of deep East Texas. Down in the valley, the Rio Grande Valley, larger Mexican-American percentages, little slower to want to jump on that bandwagon. Of course, the Oasis of Austin, you know, recoiled and still today recoils. And so, again, I think in many ways, Texas is kind of a microcosm of the country. There are a lot of places that are like, yeah, you know, now finally, you know, white kids won't be burdened with and ripped off by these affirmative action policies. I mean, that's what they believe, and they'll fight to the death on it, you know. But then there are other parts that the more urban areas, the areas in the Rio Grande Valley, that's clearly were worried. And clearly are concerned with how do we continue to enlarge opportunity, not get into, oh, you know, we're ripping off this, you know, whites to advantage this, and as you say, you know, and after all, you know, 2050, we're not going to be the majority anyway, and we better start fighting for our rights now. Otherwise, you know, when the Mexicans and the blacks and the other people of color get the upper hand numerically, you know, we're all going to hell. You know, I mean, they're going to exact revenge on us and make us eat tamales and chitlins. I mean, I don't know what they think. I mean, I mean, I read it, Southern Poverty Law Center about the Klan and the way they talk, but I mean, this is what they dream. 2050, the Turner Diaries. I don't know if you ever read the Turner Diaries and that sort of thing. I mean, they believe, Mexicans and blacks are just waiting to get the numerical political upper hand that to force all white people to eat tamales and chitlins. I mean, I don't know what the problem is, but so you got that, but that's the cultural thing. That's the cultural change that takes a while.
People don't pay attention. People don't care. We seem to have more problems, and poverty is increasing, so people go less and less to vote. They don't pay attention to who's running their town, their cities.
Yesterday, less than 20% of Massachusetts voters went to the poll. There's some reasons, including the Boston Marathon bombings that have distracted people. There is some exhaustion over Massachusetts Senate races. People are tired. But I also think there's a huge amount of apathy, and people do not see that their vote really matters. When you think your vote really matters, you go out there and vote. And the question of apathy is one that I think needs to be looked at a lot. What does it say about our population that people won't vote, even when the opportunity is there? What does it say that so many public officials will enact legislation at the local and state level that effectively makes voting more difficult and that affirmatively endorses voter suppression? Why do we do that? If the war on drugs targeted whites the way it targets blacks and Hispanics, we would not have felony disenfranchisement in most states in the United States. The studies show that blacks and whites and Hispanics use and sell drugs at approximately the same rate, with the same incidence per population. 2/3 of state prisoners across the country in those institutions for drug offenses are black and Hispanic, over 100% more than their representation in the population. I'm not sure I'm answering your question, but there are these kinds of facts that say a lot about us, and changing those facts will change the results at some point.
One of the things I want to celebrate today is, given that UMass is here, given that Smith is here, given that the data I looked at earlier and we talked about earlier about how economic status is a better predictor for the first time in the history of our country, academic success, begins to turn around when they walk through a door that has an open access institution. The baccalaureate degree begins to really help with the social and economic mobility that's embedded in the dream that Dr. King talked about. Smith College, UMass have been significant in making that transition happen. And I just want to say how much we appreciate it. When a woman graduates from GCC, goes to Smith, and then has an opportunity to read and understands the importance of reading to their child, or when they transfer off to UMass with significant financial aid, it matters. It makes a huge difference. One student at a time in our community, those big issues begin to change. And we can't thank you enough for that kind of commitment. So it's a lot to celebrate.
At Smith, we have connections with Greenfield Community College, with STIC, and also with Holyoke Community College. We also have connections with community colleges in the state of Florida and the state of California. So we, through our Ada Comstock program, admit a number of students who've gone through their first 2 years at community college. And it allows them, one, to sort of be ready for Smith, and two, not to leave Smith with a huge amount of debt. And so, I think one of the things that we don't talk about around higher ed is the need for more funding for our community colleges, which are educating over 50% or right around 50% of all of students who are in higher ed. As I said earlier, I worked at a community college, and so I know the work that happens and this campus and others across the state is invaluable and really does change lives for the students and for the community who most often return to the community. So we have to thank you.
Ask the question to the panel, if we're not out of time, what you see as the intersection of class and race and how the two are intertwined or not intertwined. It's an issue I think about all the time in my work, and I'd be curious to hear what you all think about it.
Doctor, would you like to address it?
Thank you for the question. It's a complicated kind of intersection or nexus, and in some ways, when Barack Obama made his statement about, his daughters don't need affirmative action, that there is, okay, that sounds like common sense. That sounds, fair. And yet, in another way, we also have studies upon studies that show that even the kinds of performance and the rates for participation in different aspects of society, when you control for economics, that, for example, your middle class blacks, your upper class blacks, the daughters of the Obamas, if the children Oprah Winfrey might adopt or have, or people of her class, or Jay-Z and Beyonce's little child coming up, wonderful. We find that there's still some doors, many doors in America, that despite the wealth, they're not going to get the invite. They're not going to necessarily find those doors open. And I'm talking about in the business world even, and other things. So it's a complicated. It's not something where one can say is sometimes that race is a substitute for class, or in the case of certain oppressed races in America. But I do think that back to the question that was raised, from after the Bakke decision, and I started learning more and hearing more and being in debates around affirmative action and the compelling state interest argument and all of that. My answer when folks would raise the question of a class-based system of an affirmative action based on class is, come with it, show me how it works, set it up, let's see. And if within that model, it's not only the poor white kids that get in through that class-based system, but if we can have a kind of an even percentage, 13% African American of low income are getting in, 17% Latino are getting in to the elite or the competitive or the jobs or what have you. If you can show me that within that kind of program of trying to ensure equity, that the kind of participation in that matches up with the national population demographics or the breakdown by state or what have you, then okay, I'm on board. I've just not seen, any state government, any institutions or whatever where that has effectively worked, where you're blind, you just don't look at race, don't ask about race, but you just go by economic opportunity. Because it's about who's sending the word out. How are they sending the word? This is how we're doing things. And going back to the question about the vote, where people just aren't even voting, some of what's happening is when you don't make that conscious effort to reach out to the ghetto, to the barrio, to the reservation, you don't make that conscious, open effort, they still feel the door is shut. Even though you may have the programs and the monies and the funds at the Smith, they don't even know you. So you have to have. That's what we're trying to figure out in UMass. How do we do it in a way that, as much as possible, is race neutral, if you wish, but also where it needs to be race targeted to our Native American community here, to our rising Latina and Latino and the immigrant communities and African American community. How are we reaching out in what we do to make sure that people do know that this great land-grant institution, that just is celebrating its 150th anniversary, it's trying to live up to its mission and live up to its creed, that it's a place for all people of the Commonwealth, from all economic backgrounds and from all other sorts of walks of life, to find that door is open.
Yes, sir. I think this has to be our last question, unfortunately. Thank you, Jen. Better be, the pressure's on.
The United States historically has always had pecking orders. Irish need not apply, no Jews here, etc.
Quotas.
Catholics. It goes down the line from each immigration group that has come in over time. Now, is the new racism Islam or prejudice against Islam? Because I'm seeing more assimilation between Latinos, blacks, and whites, especially among younger generations. But I'm seeing every day in newspapers, Islamic terrorists, Muslim this, Muslim that, must be a Muslim that did this, must be a Muslim that did that. Is this the new racism? And are the new influx of immigrants from Central Asia, the Arab countries, North Africa, going to be the new black in America?
I think it's a really good question, and maybe, I was just looking in the audience, we have another very able attorney here in Steve Gagnon, who's a member of the Northwestern District Attorney's Office, and I wanted to ask him, not quite your comment was a great comment. I'm going to treat it as a comment, because when I looked over and I saw him and you started to speak about the new racism, as far as the criminal justice, as far as how government responds to civil rights issues, the criminal justice system, this question was asked to me the other day. If I go over and I punch this young, brilliant scholarship award winner in the face, there will be a sanction. And if, his mother, a serious sanction. But if I hit a person of color and I use a racial epithet at the same time I hit him, there will be an enhanced sanction because it's a hate crime. And in the same spirit of poor Alan Bakke and poor Abigail Fisher, white people who are denied admission on the basis of a racial preference to remedy past injustice, what do you have to say as someone who the criminal justice system is going to vindicate my offense, which is exactly the same offense I committed for this man, but you're going to enhance the sanction?
Well, we do have protections in Massachusetts for crimes that are motivated by hostility due to a person's race, religion, ethnicity, gender. And I think the difference is, all crimes are motivated by something unpleasant. You may attack somebody or rob somebody's home or otherwise assault them because you don't like the way they look, or their religion, or their garb, their name, or it may be motivated by a personal interaction you've had with them that may be a very specific or race-neutral reason. But I think when a crime is committed with that specific purpose expressed or demonstrated, it reverberates farther than it would in an isolated victim case, because it sends a shudder of fear throughout everybody, not only in that protected class, but throughout society as a whole. So whenever we are encountered with crimes of that nature, we do take them more seriously. We do prosecute them more vigorously. We do have within our office a civil rights committee which reviews any instances where criminal conduct and civil rights violations intersect. And I think it's justified to do it that way, because it's not just a victim of a crime. It's society's really the victim, I think, when a crime of violence or other type of crime is perpetrated because of one of those motivations.
Thank you. Thank you for your comment. Great panel, great audience, great event. And look at Chris Barones. Would everybody look? Sort of like Vanna White. Okay. Thank you very much.